put you on notice when you get to that point in your argument, and you may proceed.
Thank you, Your Honor. May it please the court. My name is Kathleen DeSanto. I'm here with the Bush Ross Law Firm on behalf of Lipsey Real Estate and Holdings, Inc. And I'm actually not here to argue the case. I am proposed bankruptcy counsel in Lipsey Real Estate Holdings Chapter 11 case. As the court,
Say proposed bankruptcy counsel?
yes, Your
What does
Honor.
that mean?
Oh, there's always nuances in bankruptcy court. The bankruptcy court must approve the employment of an attorney to represent a debtor in a Chapter 11 case. During the first 21 days of a case, a bankruptcy court is not able to approve the employment of counsel. So the way we handle it procedurally in bankruptcy court, an application to employ counsel is filed under Section 330 of the Bankruptcy Code and Section 327. It is filed in what we call negative notice in the bankruptcy court. So that it remains on the docket for 14 days. If no objections are lodged, after 21 days passes, the court will enter an order approving the employment, and then I will be authorized to be counsel for the debtor.
So when we sent out our notice asking for any disagreement with our evaluation, is that something that could not have been done before today?
So two issues, Your Honor. The order asked us to file a motion with the court to seek clarification as to whether the automatic stay applies or not. And I think the court candidly was correct that the automatic stay does not apply to this action because it's affirmative relief that's being sought by the debtor. The second issue was then a procedural and more of a technical issue. And we were trying to solve that problem between now and this morning, but were unable to do so. We were hoping to be able to file an emergency application to employ special counsel so that someone could be here today to substantively handle the oral argument. But this is a case under subchapter 5 of the Bankruptcy Code, which is designed for small businesses and runs much quicker than a normal Chapter 11. There's a lot of administrative deadlines and other things that require attention in the bankruptcy court. And so attention had been focused on those items. Hill, Ward, and Henderson let me back up for a second. There are 4 appeals that arise from the underlying action that also was the reason why the bankruptcy case was ultimately filed. One of the appeals obviously is here before the court today. There's been some discussion with Hill, Ward, and Henderson as to whether they would be willing to take on this appeal as part of their representation and which of the appeals they will handle.
Well, that's actually not neither here nor there, is it? Because Mr. Lipsey was counsel of record in this case. He has not filed a motion to withdraw. Unless I'm mistaken, you have not filed a notice of appearance, and you're not indicating that you are here to present oral argument on the issues, correct?
I am not. I think there may be a problem with Mr. Lipsey, though, being able to proceed for 2 reasons. You've got the equivalent of an unrepresented corporation before you today because there isn't anyone that the bankruptcy court is authorized to be able to advance the appeal. There are 2 other issues as well, Your Honor. Section 327E of the Bankruptcy Code allows for an attorney to be employed as special counsel, provided that that attorney does not represent or hold any interest that's adverse to the debtor or the estate.
I'm going to stop you there because you're giving us far more information than is going to be helpful to us today. The only real issue, I think, at this point is whether we go forward without representation by Mr. Lipsey, whether we take the case under advisement and go forward without oral argument. And of course, I'll ask the other side to weigh in on that. But you're not telling me anything that suggests we are stayed.
I don't think the automatic stay applies here. I think you have an unrepresented party. I think that
No,
there
we
is.
have a represented party. We have an unrepresented party for purposes of oral argument.
I think the bankruptcy estate is a separate legal entity than the pre-petition debtor. So I actually do think, Your Honor, that you have an unrepresented entity. And I think there's additional analysis that would have to be done. The bankruptcy court would look at whether Mr. Lipsey would even be able to represent the bankruptcy estate in this appeal. He may not be able to.
Bankruptcy estate as we sit here today.
Yes, Your Honor, the bankruptcy estate came into effect when the petition was filed on March 3rd,
And the bankruptcy estate has not sought to intervene at this point in this case.
it automatically happens as operation of
It is.
law.
It steps in the shoes of the appellant,
The bankruptcy estate is the party to this appeal at this point.
even though there's no stay that applies.
Right, because the automatic stay applies to actions against the estate, not affirmative relief sought by the estate.
Okay, well, unless one of my colleagues has a question, I want to hear from your colleague as to their position on this issue, if any. Hold on.
May it please the court. May it please the court, my name is Melissa Santalone and I represent the attorneys in this case. I was approached half an hour ago about continuing oral arguments because of the issues with the bankruptcy action that Mr. Santos just described. I am not a bankruptcy expert at all, so I have no way to weigh in on whether this can proceed today. I am prepared to argue today. However, we did not request oral argument. That was requested by Lister Real Estate Holdings. I am fine if the court wants to forego oral argument and decide this matter on the papers. And otherwise, if the court wants to hear oral argument today, I'm prepared to go forward.
One question that I have based on the nature of this appeal, is there any prejudice to your client if this case is held in abeyance?
I would argue there absolutely is, because this action, this case is litigation between these parties has been going on since 2014.
But there is an order denying a motion to disqualify a firm, and so I'm assuming the case is still ongoing in the trial court.
Actually, summary judgment was granted in my client's favor, Your Honor.
Okay, so
Last summer.
in terms of what we do here, there may be a sort of long-term prejudice, because if there's any collection efforts or something's happening that property is going to be, I have no idea if any of this is accurate, but in the typical scenario, if there's real estate involved and there's an appeal pending, title company is not going to issue clear title on a potential sale of such property because the appeal is still pending. I don't know if there's anything like that in this case, but is there, I guess, I'm trying to ascertain if there is a delay, and there may have to be a delay. Is there anything you want to add as far as a prejudice analysis that would weigh into whatever we do?
No, Your Honor, there's nothing specific other than additional fees for having to come back someday to argue this one. Time's appropriate.
Very good. Unless my colleagues have a question. Counsel, you said you had some more you wanted to offer. Thank you very much.
Thank you, Your Honor. I'll be brief and I appreciate the indulgence. Along the prejudice lines, the other thing I would add is the debtor has to use business judgment in evaluating whether to ultimately pursue this appeal any farther. And I think the analysis is a little different now that the debtor is in a bankruptcy case. There will have to be a cost-benefit analysis with respect to pursuing and concluding this appeal. Debtor's going to need to look at the likelihood of success, the cost of attorney's fees, especially if Mr. Lipsey isn't able to serve as counsel under the analysis that the bankruptcy court's going to have to do, and the potential for exposure to the estate.
What kind of time frame are we looking at? Is there any expectation that the bankruptcy court will do anything that helps us figure out what we're going to do?
Absolutely, Your Honor. I think we can get this resolved and we just have 30.
I'm sorry, lower the microphone just a little bit. There you go.
Thank you. We shouldn't need long, Your Honor, just 30 days. A very brief continuance here should give us the opportunity to employ special counsel if that's the route the estate decides to go, or if, in sort of sorting the wheat from the chaff here, if this is an appeal that the estate doesn't deem worthy to pursue because the cost of having to continue to litigate it to make the decision to dismiss the appeal. So these are all things that I think we could accomplish very easily in the bankruptcy court the next 30 days.
Any questions? We will be conferring afterwards to decide what to do. So thank you for coming in. Have you given your name to the side bid outside so we know who you are?
I did. Thank you so much for indulging this morning, and I'm sorry to be a little bit of a fly in the moment. I appreciate it.
Well, thank you for the information that you've provided. We appreciate that.
Thank you.
So that will conclude for today the case of Lipsey Real Estate versus Victory Laws. The next case is City of Tampa versus Burlington.